Before we dive in, it's crucial to understand that the information in this video is for educational purposes only and does not constitute legal advice. I am not your attorney, and watching this presentation does not create an attorney-client relationship. Always consult with a qualified legal professional for advice regarding your specific situation. You see a certified letter in your mailbox. Your stomach drops. You open it, and your eyes glaze over as you scan a wall of text. Words like heretofore, indemnify, without prejudice, and stipulation jump out at you. Your heart pounds. Are you being sued? Did you do something wrong? You try to read it, but it feels like it's written in a completely different language, designed to confuse and intimidate you. That feeling of powerlessness, of being lost in a sea of jargon that ends today. This isn't just a vocabulary lesson. This is your personal translator for the language of law. We are going to demystify the critical legal terms you encounter every single day. Whether you're signing a lease for a new apartment, clicking I agree on a website's terms of service, starting a small business, or even just trying to understand a news story about a major court case. By the time we're done, you'll have a new kind of confidence. You'll be able to spot red flags in a contract, understand your rights, and feel empowered instead of intimidated. We're going to hand you the keys to a language that, until now, has been locked away for a select few. So let's start at the very beginning, the absolute foundation of almost any legal dispute. You've heard these two words on every TV show, but what do they actually mean? Plaintiff and defendant. Simpler than you think. Imagine a schoolyard argument that gets taken to the principal's office. The plaintiff is the person who starts the formal complaint. They're the one pointing the finger saying, "He took my lunch money." They are complaining about something, so they file a complaint. In the legal world, they are the ones initiating the lawsuit. The defendant is the one being accused. They are the one who has to defend themselves against the accusation. "Nah, I didn't." In this scenario, the defendant is the one being sued, the one the plaintiff is seeking something from, usually money or for them to stop doing something. So plaintiff complains, defendant defends. That's it. Knowing this simple distinction is the first step to understanding any court case you ever read about. Now, what is the plaintiff usually trying to prove? They're trying to prove that the defendant is liable. Liability. This is a huge one. You hear it everywhere. Liability insurance, limited liability company, admitting liability. All it means is legal responsibility. If you are found liable for something, you are legally on the hook for it. You are the one who has to pay or fix the problem. Let's say you're driving and you run a red light, causing an accident. You are liable for the damage to the other car and any injuries you caused. It's your legal responsibility. Or if a customer slips on a wet floor in a grocery store that didn't put up a wet floor sign, the store is likely liable for that person's injuries. The responsibility falls on them. This concept is the bedrock of civil law. It's all about determining who is responsible, who is liable, when something goes wrong. This is why companies and individuals buy insurance, to protect themselves from the massive financial costs that can come with being found liable. And you'll see phrases like limited liability, especially with businesses. This is a legal structure, like an LLC, designed to protect the business owner's personal assets, their house, their car, their savings, from being used to pay for the business's liabilities. It creates a shield between the person and the company. So, liability is about responsibility, often after something has already gone wrong. But what about the documents we sign to prevent things from going wrong in the first place? That brings us to one of the most important words in the entire legal and business world: contract. A contract is not just a long, complicated document filled with fine print. At its core, a contract is simply a legally enforceable agreement. It's a set of promises that the law will back up. And for a contract to be valid in the United States, it generally needs three key ingredients: offer, acceptance, and consideration. First, you need an offer. This is a clear proposal from one person to another. "I will sell you my used lawnmower for $200. That's an offer. It's specific and shows a willingness to enter into an agreement. "I'm thinking about selling my lawnmower someday" is not an offer. It's too vague. Second, you need acceptance. This is the other person's clear agreement to the terms of the offer. If you say, "I accept, I'll buy your lawnmower for $200, you have acceptance. The deal is mirrored. However, if you say, "I'll take it for $150, that's not acceptance. That's a counteroffer, which kills the original offer. The first person would then have to accept your new offer of $150. Now for the third and most commonly misunderstood ingredient, consideration. This sounds fancy, but it's just a legal term for something of value. For a contract to be real, both sides have to give up something of value. There has to be a two-way exchange. In our lawnmower example, one person gives up the lawnmower, and the other person gives up $200. The lawnmower is consideration, and the money is consideration. Both parties are getting something and giving something. This is why a promise to give a gift is usually not a legally enforceable contract. If your rich uncle says, "I'm going to give you $10,000 next week for your birthday," and then he doesn't, you can't sue him. Why? Because you didn't give him anything of value in return. There was no consideration from your side of the deal. It was a one-way promise. So, offer, acceptance, consideration. You need all three for a contract to be valid. Okay, so you have a valid contract. Everyone knows the deal. But what happens if someone doesn't hold up their end of the bargain? That's called a breach of contract. A breach is simply the failure to perform your duties under the contract without a valid legal excuse. If you paid your $200, but the seller refuses to give you the lawnmower, they have breached the contract. If they give you the lawnmower, but you refuse to pay, you have breached the contract. It's the legal term for a broken promise that was part of a valid agreement. When a breach happens, the law provides a remedy for the person who was wronged. And that remedy usually comes in the form of our next key term, damages. When you hear damages in a legal context, don't just think of a dented car. Damages means money. It's the monetary award a court orders the breaching party to pay to the innocent party to compensate for the harm caused by the breach. The whole point is to put the innocent person in the position they would have been in if the contract had been fulfilled. There are two main types of damages you should know. The first is compensatory damages. The word compensate is right in there. This is money to compensate you for your actual measurable loss. If you paid $200 for a lawnmower you never got, your compensatory damages would be $200 to make you whole again. If you had to then go out and spend $250 on a similar lawnmower because the seller backed out, your damages might be the $50 difference you had to pay. The second type, which you see in big splashy news headlines, is punitive damages. The word punish is the key here. This isn't about compensating the victim for their loss. This is about punishing the wrongdoer for particularly outrageous, fraudulent, or malicious behavior. Punitive damages are intended to make an example of the defendant and deter them, and others, from acting that way in the future. You don't see punitive damages in a simple contract case like our lawnmower example. You see it in cases where a company knowingly sold a dangerous product that injured people, or an insurance company acted in bad faith and refused to pay a legitimate claim. It's the court's way of saying, what you did was so wrong that just paying for the harm you caused isn't enough. You need to be punished. Think of punitive damages as the legal system's version of a red card in soccer. It's not just about the foul. It's about sending a message to the entire league that this kind of behavior won't be tolerated. But this whole system of damages, compensatory, punitive, you name it, doesn't just happen in a vacuum. It's the end result of a long, structured battle. And every battle needs combatants. In the legal world, we call them the plaintiff and the defendant. These are two of the most fundamental terms you'll ever hear. The plaintiff is the one who starts the fight. They are the person, the group, or the company that feels they've been wronged. They're the ones who walk into the courthouse, metaphorically speaking, and file the paperwork that gets the whole process started. The word itself comes from the same root as plaintive, which means sounding sad or mournful. The plaintiff is literally the one making a complaint. On the other side, you have the defendant. The defendant is the one being accused of causing the harm. They are the ones who have to defend themselves against the plaintiff's claims. So, if you slip and fall in a grocery store because of a wet floor with no sign, you are the plaintiff. The grocery store corporation is the defendant. If a company steals your patented invention, you're the plaintiff and they are the defendant. It's the person pointing the finger versus the person the finger is pointed at. This formal public dispute between the plaintiff and the defendant is called a lawsuit, or, more formally, litigation. When you hear that someone is litigious, it means they're someone who tends to sue people often. Litigation is the entire process, from the first piece of paper filed to the final verdict from a judge or jury. It's the arena where the plaintiff and defendant clash, governed by a strict set of rules. So how does this battle officially begin? It starts with a document called the complaint, or in some states, a petition. This isn't just a letter saying, "I'm mad at you." It's a highly structured legal document that acts as the opening salvo. The complaint lays out the plaintiff's entire story. It identifies who the plaintiff is, who the defendant is, and explains the facts of the case from the plaintiff's perspective. It will say, on this date at this location, this is what the defendant did. Then crucially, it breaks down the legal arguments, listing specific causes of action, things like negligence, breach of contract, or defamation. Finally, it tells the court what the plaintiff wants. This is called the prayer for relief, and it's where they'll ask for a specific amount of money in damages, or for the court to order the defendant to do something or stop doing something. Once this complaint is filed with the court, it can't just sit there. The defendant has to be officially notified. This is where you get that classic movie scene. A stranger walks up to a character on the street, hands them a stack of papers and says, "You've been served." This is real, and it's called service of process. It is a cornerstone of the American legal system. You cannot be sued in secret. The Constitution guarantees something called due process, which in simple terms means fairness. And part of that fairness is the right to know you're being sued and have an opportunity to defend yourself. Process refers to the official court documents, usually a copy of the complaint and a summons, which is a formal notice from the court ordering the defendant to appear and respond. Service is the act of delivering these documents. It's often done by a county sheriff's deputy or a private process server hired for the job. They have to follow strict rules to ensure the delivery is valid, sometimes requiring them to hand it directly to the person or leave it with a competent adult at their home. This step is so critical that if it's done improperly, a defendant can sometimes get the entire case thrown out. Okay, so the defendant has been served. They're holding the complaint. Now what? They can't ignore it. If they do, the court can issue a default judgment, meaning the plaintiff wins automatically because the other side didn't even show up to fight. To avoid that, the defendant must file a response, typically called an answer. The answer is the defendant's chance to tell their side of the story. It systematically goes through every single allegation the plaintiff made in the complaint and responds to each one. For each claim, the defendant will typically admit it's true, deny it's false, or state that they lack sufficient information to either admit or deny it. The answer is also where the defendant can raise affirmative defenses, reasons why they shouldn't be held liable, even if the plaintiff's claims are true. For example, they might argue the plaintiff waited too long to sue. And this brings us to a hugely important concept, the statute of limitations. This is one piece of legal jargon everyone should know, because it can affect your rights directly. A statute of limitations is essentially a legal deadline. It's a law that sets the maximum amount of time a person has to file a lawsuit after something happens. If you miss the deadline, your claim is gone forever, no matter how strong your case was. These deadlines vary dramatically depending on the type of case and the state you're in. For a personal injury claim from a car accident, you might have 2 years. For a breach of a written contract, it could be 4 or 5 years. For medical malpractice, it might be shorter and have very complex rules about when the clock even starts ticking. Why do these deadlines exist? For a few key reasons. First, fairness to the defendant. It's not fair to have the threat of a lawsuit hanging over your head indefinitely. People and businesses need to be able to move on. Second, evidence gets stale. Memories fade, witnesses move away or pass away, and documents get lost. The legal system wants to decide cases based on the best available evidence, and that means hearing them while the trail is still relatively fresh. So the statute of limitations forces the plaintiff to act promptly. It's the law's way of saying, use it or lose it. Now, before this legal battle can truly get underway, there's a foundational question the court has to answer for itself. Does it even have the power to decide this case? This power is called jurisdiction. It's a court's legal authority to hear a case and make a judgment that is legally binding on the parties. Without jurisdiction, a court is powerless, and any decision it makes is worthless. There are 2 main types of jurisdiction you need to know. The first is subject matter jurisdiction. This is the court's authority over the type of case. Think of courts as specialists. You have traffic courts, family courts, bankruptcy courts, and so on. You wouldn't take a multi-million-dollar patent dispute to a small claims court that's designed to handle disputes under $5,000. You wouldn't file for divorce in a federal court that deals with federal laws. Subject matter jurisdiction ensures that the right kind of case is in the right kind of court. The second, and often more complicated type, is personal jurisdiction. This is the court's authority over the people or companies involved in the lawsuit, specifically, the defendant. For a court in Texas to have personal jurisdiction over you, you generally need to have some connection, some minimum contacts, with the state of Texas. If you live in Maine, have never been to Texas, own no property there, and the incident you're being sued over happened entirely in Maine, a Texas court has no power over you. The plaintiff would have to sue you in Maine. This principle becomes much more complex in the age of the internet. If a company in California sells a product online to a customer in Florida, and that product injures the customer, can the customer sue the company in a Florida court? The answer is maybe. Courts will look at whether the company purposefully directed its business activities toward Florida. Did they advertise there? Did they ship a lot of products there? It's a question of fairness. Is it fair to force this defendant to travel across the country to defend a lawsuit in a state they have little to do with? So let's recap the opening moves of this legal chess match. An incident occurs. The plaintiff, believing they've been legally wronged, must act before the statute of limitations, that ticking clock, runs out. They file a complaint with the court that has both subject matter and personal jurisdiction. That complaint is then formally delivered to the defendant through service of process. The defendant then responds with an answer, and the battle lines are officially drawn. But this is just the beginning. This is just setting up the board. Once the initial paperwork is filed, the real work begins. The phase where secrets are revealed, evidence is unearthed, and the true strength of each side's case is tested. This is where the lawyers start digging. It's a process of forced information sharing, designed to prevent trial by ambush and ensure everyone knows what cards the other side is holding. And the first way they demand to see those cards is through a set of tools that, together, are known as discovery. Think of it as the mandatory show and tell of the legal world. It's a series of formal procedures where each side can demand evidence and information from the other. This isn't about politely asking, it's about legally compelling them to hand it over. Failure to comply can result in serious penalties from the judge, a concept we call sanctions. The most common tool, and usually the first one out of the box, is a set of written questions called interrogatories. It's a fancy word for a simple concept. One lawyer sends a list of questions to the other party, and that party is legally required to answer them in writing under oath. These aren't casual queries. They are painstakingly crafted to pin down the basic facts of the case. In our car accident example, the plaintiff's lawyer might send interrogatories to the defendant asking, "State the name and address of every person who was in your vehicle at the time of the collision. Were you using a cellular device at the time of the incident? If so, state the number you were using and the carrier. List every alcoholic beverage you consumed in the 12 hours preceding the collision." The other side can't just ignore these. They have to answer. But here's the catch. The answers are almost always filtered through their lawyer. The lawyer will help them phrase the answers in the most favorable, and often the most limited, way possible. If a question is vague, they'll give a vague answer. If a question is poorly worded, they might object to it entirely. It's a strategic dance. The goal of the person asking is to get concrete facts and identify potential witnesses. The goal of the person answering is to give away as little strategic ground as possible while still complying with the law. So while interrogatories are great for establishing a baseline of facts, they rarely deliver that aha, Perry Mason moment. For that, you have to dig deeper. The next shovel in the lawyer's shed is the request for production of documents, or RFP. This is where the phrase "show me the receipts" becomes a legal command. It's a formal demand for the other side to produce tangible evidence. Documents, emails, text messages, photographs, videos, financial records, medical bills. Anything that can be recorded and is relevant to the case. This is the put your cards on the table moment. If you claim you were injured and couldn't work, the other side will demand your medical records, your employment files, and your tax returns. If you claim a company stole your trade secret, you'll demand their internal emails, their product blueprints, and their research notes. In the modern age, this has exploded into what we call e-discovery, or electronic discovery. We're no longer just talking about a few file boxes. We're talking about terabytes of data. Lawyers now use sophisticated software to search through millions of emails and digital files for specific keywords. It can be incredibly expensive and time-consuming. Sometimes, a less scrupulous party might try to bury their opponent in irrelevant documents, a tactic known as a document dump. They'll hand over 1 million pages of information, hoping the one crucial, damning email gets lost in the noise. But a good legal team knows how to sift through that noise to find the signal. The RFP is powerful because documents don't lie in the same way people can. An email sent a year ago is a frozen moment in time, a powerful piece of the puzzle that can't be easily explained away. But documents and written answers only tell part of the story. To truly understand the case, you need to hear from the people involved. And for that, we have the most dramatic, high-stakes part of the discovery process, the deposition. A deposition is a formal, sworn interview that takes place outside of court. Imagine sitting in a sterile conference room. On one side of a long table sits the witness, called the deponent. Next to them is their lawyer. Across the table is the opposing counsel, ready to ask the questions. And at the head of the table sits a court reporter, typing every single word that is said on a stenography machine, creating an official transcript. Everything said in a deposition is under oath, just as if you were in a courtroom testifying before a judge and jury. Lying in a deposition is perjury, a serious crime. There is no judge present to rule on objections, but the lawyers can still make them for the record. The deponent's lawyer is there mostly to advise their client. Don't answer that, or don't speculate. But they can't answer for them. The witness is on their own. The goal of a deposition is threefold. First, the lawyer wants to find out what the witness knows. What did they see? What did they hear? What did they do? Second, they want to lock the witness into their story. Because there's a written transcript, if that witness tries to change their story later at trial, the lawyer can stand up in front of the jury and say, "But on May 15th in your deposition under oath, you said the exact opposite, didn't you?" It completely destroys the witness's credibility. And third, and perhaps most importantly, the lawyer gets to size up the witness. Are they believable? Do they get angry easily? Do they seem honest or shifty? How will a jury perceive this person? A witness who comes across as arrogant and evasive in a deposition will likely do the same on the witness stand, which can be devastating for their case. A deposition can last for hours, sometimes even days. The questioning can be grueling, designed to test the witness's memory and consistency. It is a psychological pressure cooker, and it's often where cases are won or lost, long before a jury is ever selected. If a key witness completely falls apart in their deposition, the other side knows they have immense leverage, and the case will very likely settle right then and there. Sometimes, people who aren't even part of the lawsuit have crucial information. To get them to a deposition, lawyers use a court order called a subpoena, which legally compels that person to show up and testify or produce documents. Finally, after all the questions have been answered, the documents produced, and the witness is deposed, there's one more tool designed to streamline the process. They're called requests for admission, or RFAs. These are a series of simple, direct statements that one party sends to the other, asking them to either admit or deny the truth of the statement. For example, admit that you were the driver of the blue Honda Civic involved in the collision. Admit that the collision occurred at the intersection of Main Street and Elm Street. Admit that you were sent the attached invoice on June 1st. The purpose isn't to discover new information, but to narrow down the issues that are actually in dispute. If the other side admits a fact, it is considered proven for the purposes of the case. You don't have to waste time and money bringing in a witness at trial just to prove that, yes, the defendant was in fact driving the car. It's a way of getting the uncontroversial stuff out of the way so that the trial can focus on what the parties truly disagree on, like who had the green light. It's the final step in laying all the cards on the table, forcing each side to show their hand on the basic facts. Once discovery is complete, the fog of war begins to lift. Both sides now have a much clearer picture of the evidence. They know the strengths and weaknesses of their own case, and crucially, the strengths and weaknesses of their opponents. And so, with the cards on the table, the real chess match begins. This isn't just about preparing for a trial anymore. It's about trying to win the war before the first shot is even fired in the courtroom. And the single biggest weapon to do that is called a motion. A motion, in its simplest form, is just a formal request made to the judge. That's it. It's a lawyer standing up, either in person or on paper, and saying, "Your Honor, I am asking the court to do something." That something could be minor, like asking for more time to file a document, or it could be a case-ending, game-changing bombshell. And the biggest bombshell of them all is the motion for summary judgment. This is the legal equivalent of a knockout punch. It's one party, usually the defendant, going to the judge after discovery is complete and saying, "Your Honor, look at everything we've gathered. Look at the depositions, the documents, the admissions. Based on all of this undisputed evidence, there's no way the other side can possibly win. There's no point in even having a trial. You should just declare us the winner right here, right now." The legal standard for this is a phrase you might hear thrown around. No genuine dispute as to any material fact. Let's break that down because those words are chosen very, very carefully. Material fact means a fact that actually matters to the outcome. If two people in a car crash are arguing about whether the defendant's car was dark blue or black, that's a dispute of fact, but it's not material. It doesn't change who ran the red light. But the color of the traffic light? That is the very definition of a material fact. Then there's the phrase, genuine dispute. This means there has to be a real, legitimate argument about that material fact, supported by some kind of evidence. It can't just be one person saying, "Nah, the light was green," when 3 witnesses and a traffic camera all show it was red. In that case, there's no genuine dispute. The evidence is overwhelming. So, when a lawyer files for summary judgment, they are creating a detailed, evidence-backed argument that says, even if we look at all the evidence in the light most favorable to the other side, the law is so clearly on our side that we must win. They attach exhibits, excerpts from depositions, copies of contracts, photographs, expert reports, to prove their point. Imagine you're the plaintiff's lawyer in that car crash case. You get this massive document from the other side. It's a gut punch. The defendant is arguing that in your own client's deposition, he admitted to looking down at his phone to change a song just before the intersection. They attach that transcript page. They also attach an affidavit from an eyewitness who says your client was speeding. They're telling the judge, there are no material facts in dispute here. The plaintiff was distracted and speeding. We are entitled to judgment as a matter of law. The case could end right there. Everything you've worked for gone. So what do? You file an opposition. Your job in the opposition to the motion for summary judgment isn't to prove you win the case. Your job is much simpler. You just have to show that there is a genuine dispute. You have to show the judge that there's a question a jury needs to decide. Maybe you have your own affidavit from a different witness who says the defendant's car was the one that seemed to be speeding. Maybe you have a report from an accident reconstruction expert who says the physical evidence at the scene suggests the defendant had to have been the one who ran the red light, regardless of what your client was doing with his radio. You're not asking the judge to believe your witness over theirs. You're just saying, Your Honor, we have 2 conflicting stories here. Deciding who is more believable is the literal job of a jury. You can't end the case now. The judge then looks at everything, the motion, the opposition, all the evidence, and they make a decision. They can grant the motion, which means the case is over, the defendant wins. They can deny the motion, which means the case will proceed to trial. Or they can grant in part and deny in part, maybe knocking out one of the plaintiff's claims but leaving others intact. This moment, waiting for the judge's ruling on summary judgment, is one of the most nerve-wracking parts of any lawsuit. But the motion does something else too. It creates a crisis point. It forces everyone to stare into the abyss and confront the true strengths and weaknesses of their case. And that makes it the perfect time to talk about settling. Over 90% of civil cases in the United States never reach a trial. They end in a settlement. And the pressure of a pending summary judgment motion is often the catalyst. This is where you hear 2 more critical terms, mediation and arbitration. People often use them interchangeably, but they are fundamentally different. Let's start with mediation. Think of mediation as a structured, confidential negotiation facilitated by a neutral third party, called a mediator. The mediator is usually a retired judge or an experienced lawyer. Their job is not to make a decision. They have no power to force anyone to do anything. Their only job is to help the 2 sides reach their own agreement. Typically, everyone convenes at a neutral office. The mediator might bring both parties and their lawyers together in one conference room to start, letting each side briefly state their case. This is often the first time the actual clients have been in the same room. Then, the mediator separates them into different rooms. For the rest of the day, the mediator acts as a shuttle diplomat. They'll go into the defendant's room and say, "Okay, I heard what you said. But let me tell you, the plaintiff's story about their injuries is very sympathetic. A jury might really connect with them. Are you sure you want to risk a $10 million verdict when you could settle this today for a fraction of that?" Then the mediator walks across the hall to the plaintiff's room and says, "Look, I understand you're angry, but they have a strong motion for summary judgment pending. There's a real chance the judge could throw your case out entirely, and you'll get nothing. Are you sure you want to risk getting 0 when you could walk away today with a guaranteed check in your pocket?" The mediator reality tests both sides. They poke holes in their arguments. They convey offers back and forth. It's a long, emotionally draining process. But because it's non-binding, It's a safe way to explore settlement without showing your hand. You can find out what the other side is really thinking and what they might be willing to live with. If you reach a deal, you sign a settlement agreement and the case is over. If you don't, you just walk away and head back to court with no one the wiser. Arbitration, on the other hand, is a completely different animal. Arbitration is essentially a private trial. Instead of a judge and a jury, you have an arbitrator or a panel of 3 arbitrators who listen to the evidence and then render a decision just like a judge would. Witnesses can be called, evidence can be presented. It's a more streamlined, less formal version of a trial. But here is the crucial difference. In most cases, arbitration is binding. That means the arbitrator's decision, called an award, is final. You can't just appeal it because you don't like the outcome. The grounds for appealing an arbitration award are incredibly narrow, usually limited to things like fraud or bias on the part of the arbitrator. So why would anyone agree to this? Often you don't have a choice. Look through the terms and conditions for your cell phone, your credit card, your bank account. Chances are you'll find a mandatory arbitration clause. By signing that contract, you gave up your right to sue the company in court and agreed that any dispute would be handled by a private arbitrator. Companies prefer it because it's faster, cheaper, and most importantly, private. There are no public court filings, no runaway jury verdicts. So as the lawyers stare down the barrel of a summary judgment ruling, these are their options. Do they risk everything on the judge's decision? Do they try to find a middle ground in the safe, non-binding world of mediation? Or are they already locked into the binding, all-or-nothing world of arbitration? Let's say in our case, the parties try to mediate, but they're too far apart. They can't reach a deal. They return to their respective corners and wait. Finally, an email from the court clerk arrives. The judge has ruled on the motion for summary judgment. The lawyers hold their breath, open the attachment and read the first line. The motion is denied. The knockout punch has failed. The case is not over. In fact, the real battle, the one in front of a jury, is now just about to begin. And that battle is fought in a courtroom, a modern-day arena where stories clash and a person's fate can be decided by 12 strangers. This is the trial. It's the part of the legal process that movies and TV shows love, but the reality is far more structured and far more fascinating than you might think. Before the first witness is ever called, before the first piece of evidence is shown, the most crucial part of the entire trial happens, selecting the jury. This process has a fancy French name, voir dire. It literally means to speak the truth. And that's exactly what it's about. A group of potential jurors called the jury pool or the venire are brought into the courtroom. The judge and the lawyers for both sides then get to ask them questions. The goal isn't just to find 12 people. It's to find 12 impartial people. People who can listen to the evidence and make a decision based only on the facts presented in court, not on their preconceived notions or personal biases. In our exploding gadget case, Sarah's lawyer might ask the potential jurors, have any of you ever worked for a large technology company? Or do you have strong feelings about personal injury lawsuits? The company's lawyer will ask their own questions. Do you believe that sometimes people misuse products and then blame the manufacturer? Or have you ever returned a product because you couldn't figure out how to use it correctly? What they're doing is probing for bias. If a potential juror says, yeah, my brother was fired from a big tech company and I think they're all evil, Sarah's lawyer might be thrilled, but the company's lawyer is going to want that person off the jury. And they have 2 ways to do it. The first is a challenge for cause. This is when a lawyer argues to the judge that a juror has an obvious, stated bias and simply cannot be impartial. The juror who thinks all tech companies are evil? That's a classic challenge for cause. There's no limit to how many of these a lawyer can make. If the judge agrees there's a clear bias, that juror is dismissed. But what about the juror who doesn't say anything biased, but just gives the lawyer a bad feeling? The one who has their arms crossed and a skeptical look on their face the whole time? For this, lawyers use a peremptory challenge. This is a special power where each side can strike a certain number of jurors without giving any reason at all. It's a gut check removal. The lawyer just doesn't like the vibe they're getting. There are limits, of course. You can't use peremptory challenges to exclude jurors based on their race, ethnicity, or gender. But it remains one of the most powerful and strategic tools a trial lawyer has. After this intense game of human chess, a jury is finally selected and sworn in. The stage is set, and the show begins with opening statements. This is the first time each lawyer gets to speak directly to the jury and tell them their side's version of the story. It's the trailer for the movie they're about to present. Sarah's lawyer will stand up and paint a picture of a loyal customer. A woman who trusted a brand, only to be betrayed by a dangerous product that turned her life upside down. They'll lay out a roadmap. We will show you through expert testimony how this device was defectively designed. We will present evidence that the company knew about the risks. And you will hear from Sarah herself about the pain and suffering this has caused. Then the defense lawyer gets their turn. They'll offer a competing narrative. This is a case about responsibility, they might begin. Our company has sold millions of these devices safely, but the evidence will show that the plaintiff, Ms. Adams, failed to follow the clear instructions in the user manual. This wasn't a product failure. It was a user error. Crucially, nothing said in an opening statement is evidence. It's just a promise of what the evidence will show. Now they have to deliver on that promise. And that happens through witnesses and exhibits. This is the case in chief. The plaintiff, Sarah, goes first. Her lawyer will call their first witness to the stand. Let's say it's Sarah herself. The questioning that her own lawyer does is called direct examination. The goal of direct examination is to let the witness tell their story in a clear, compelling way. The lawyer acts as a guide, asking open-ended questions that start with who, what, where, when, why, and how. Ms. Adams, where were you on the night of the incident? What did you observe? How did you feel? Notice the lawyer isn't feeding her the answers. In fact, on direct examination, you are generally not allowed to ask leading questions, questions that suggest the answer. A leading question would be, you were in a lot of pain, weren't you? That's a big no-no. The witness has to be the one telling the story, not the lawyer. But once Sarah's lawyer is finished, the entire tone in the courtroom shifts. The defense lawyer stands up, walks to the lectern, and begins the cross-examination. This is the part that creates courtroom drama. The purpose of cross-examination is to test the truthfulness and accuracy of the witness's testimony. The opposing lawyer's job is to poke holes in the story, to highlight inconsistencies, and to get the witness to admit facts that are helpful to the other side. And here the rules flip. On cross-examination, leading questions are not only allowed, they are the primary tool. The defense lawyer wants to control the witness, to limit their answers to a simple yes or no. The questions will be sharp and precise. Ms. Adams, you received a user manual with the product, correct? Yes. And that manual contained a warning section, did it not? Yes. And isn't it true that on page 5, it specifically warns against leaving the device plugged in overnight? You can feel the tension. Every question is a strategic move designed to chip away at Sarah's story and build up the defense's narrative of user error. Throughout this entire process, the other lawyer is listening like a hawk. If they hear a question or an answer that they believe breaks the rules of evidence, they'll stand up and say, objection, This is a formal protest to the judge. There are dozens of possible objections, but some are more common than others. The most famous is hearsay. In simple terms, hearsay is an out-of-court statement being used in court to prove that what the statement says is true. For example, if Sarah's lawyer asks her, "What did your neighbor Bob tell you he saw?" That's hearsay. Sarah is trying to use Bob's statement as evidence. The reason it's not allowed is fundamental to our justice system. The other side can't cross-examine Bob. They can't test his memory, his perception, or his truthfulness. If you want to know what Bob saw, you have to put Bob on the stand under oath and ask him directly. Another common objection is relevance. The evidence being presented has to actually have something to do with the case. If the defense lawyer starts asking Sarah about a speeding ticket she got 10 years ago, her lawyer will object. Objection, Your Honor. Relevance. What does a 10-year-old speeding ticket have to do with a defective product? Nothing. It's just an attempt to make her look bad. Lawyers also object to questions that call for speculation. What do you think the engineer who designed the battery was thinking? A witness can't read minds. They can only testify about what they saw, heard, and did. When a lawyer objects, the judge has two choices. If the judge agrees the objection is valid, they will say, sustained This means the question must be rephrased or the witness should not answer. If the judge disagrees, they will say, overruled The question stands and the witness must answer. This rapid-fire exchange of questions, answers, and objections is the rhythm of a trial. It's a dance of rules and strategy, all aimed at controlling the flow of information to the jury, ensuring that what they hear is proper, relevant evidence, upon which they can base a just decision. And as Sarah steps down from the witness stand, her face flushed from the brutal cross-examination, Her lawyer calls their next witness, an engineering expert who they believe will be their key to victory. The real fireworks are just getting started. The woman who approaches the stand is the polar opposite of Sarah. Where Sarah was emotional and visibly shaken, Dr. Evelyn Reed is a picture of calm authority. She's in her late 50s with a sharp, intelligent gaze that sweeps over the courtroom, briefly landing on the jury with an air of academic confidence. She's an expert witness. This is a crucial distinction. A regular witness, a lay witness, can only testify about what they saw, heard, or personally experienced. They can give facts. An expert is different. Because of their specialized knowledge, skill, experience, or training, a judge can permit them to give their opinion on a matter. They are there to help the jury understand complex subjects they wouldn't normally be able to, like structural engineering, forensic accounting, or medical malpractice. But you can't just declare yourself an expert. Sarah's lawyer has to lay the foundation. This is a legal term for the preliminary work a lawyer must do to show that a piece of evidence is admissible, or in this case, that a witness is qualified to give an expert opinion. So Sarah's lawyer begins a calm, methodical series of questions. Dr. Reed, could you please state your full name for the record? Could you tell the court where you received your doctorate in civil engineering? That would be the Massachusetts Institute of Technology, correct? And could you summarize for the jury your 30 years of experience in the field of structural failure analysis? He's building a tower of credibility, brick by brick. He asks about the books she's published, the industry board she sits on, the dozens of times she's been qualified as an expert in courtrooms just like this one. This isn't just for show. It's a legal requirement. He is demonstrating to the judge that Dr. Reed's opinion is worth hearing. Just as he's about to ask her about the case itself, Megacorp's lawyer rises smoothly. Your Honor, permission to conduct voir dire on the witness's qualifications? Now, you've probably heard of voir dire during jury selection, where lawyers question potential jurors. But it can also be used here, as a mini cross-examination of an expert's credentials before they give their main testimony. It's a strategic move by the opposition to try and knock the expert down a peg, or even get them disqualified entirely, before they can say a single word to influence the jury. The judge nods. Permission granted. The Megacorp lawyer approaches Dr. Reed, his tone dripping with false respect. Dr. Reed, a prestigious career indeed. I see from your curriculum vitae, your primary focus has been on municipal bridges. Is that correct? Dr. Reed answers calmly. It has been a significant part of my work, yes. The lawyer pounces. In fact, over 80% of your published work relates to bridge and overpass integrity. You've only consulted on a handful of commercial buildings like the one in question, haven't you? He's trying to frame her as a fish out of water, an expert in the wrong pond. He then pivots. And doctor, could you tell the jury how much you are being compensated for your time here today? Is it true the plaintiff's firm is paying you $500 an hour for your testimony? He's planting a seed of doubt. Is she an impartial scientist, or just a hired gun, paid to say whatever Sarah's lawyer wants? Dr. Reed remains unflustered, explaining how her engineering principles apply universally, and that her fee is standard for her level of expertise, regardless of the client. The judge, unimpressed by Megacorp's attempt to rattle the witness, declares Dr. Reed qualified to testify as an expert in structural engineering. In some cases, a lawyer might make what's called a Daubert motion. This is a specific challenge arguing that the expert's methodology isn't based on scientifically valid reasoning. It's the judge's job to be a gatekeeper, to ensure the jury only hears expert testimony that is both relevant and reliable. Here, the judge sees no such issue, and waves for Sarah's lawyer to proceed. The foundation is laid. The challenges have been met. Now the real testimony begins. This is the direct examination of the expert. Sarah's lawyer walks Dr. Reed through the evidence. The building's original blueprints, maintenance logs, photographs of the debris. He asks her to explain technical concepts like tensile strength and load-bearing capacity in simple, everyday language for the jury. He's using her as a translator, turning complex engineering into a clear story of negligence. Then he gets to the heart of the matter. He uses a classic and powerful tool, the hypothetical question. He says, Dr. Reed, I want you to assume a few things for me. Assume that a ceiling support system is designed to use quarter-inch galvanized steel anchor bolts, as specified in the blueprints you've reviewed. Now assume that instead of those bolts, a contractor used cheaper 1/8-inch zinc-plated bolts. And assume that this structure was then subjected to the normal heating, cooling, and humidity fluctuations of this region for 5 years. Based on these assumptions, and to a reasonable degree of scientific certainty, what is your professional opinion on what would happen to that support system? Megacorp's lawyer shoots to his feet. Objection. Calls for speculation. This is a common objection. You can't ask a regular witness to guess what might have happened. But Dr. Reed isn't a regular witness. Sarah's lawyer calmly replies, Your Honor, this is not a call for speculation. It's a request for an expert opinion based on a set of hypothetical facts that mirror the evidence already presented. A proper foundation has been laid. The judge agrees. Objection overruled. The witness may answer. The courtroom is silent. Every juror is leaning forward. Dr. Reed looks directly at them and says, clearly and without a hint of doubt, the zinc-plated bolts would suffer catastrophic shear failure. The lower tensile strength and inadequate corrosion resistance would make the collapse of the ceiling not just a possibility, but an inevitability. It was a ticking time bomb. The words hang in the air. This is the moment Sarah's team has been building towards. It's an expert, a scientist from a top university, telling the jury that Megacorp's cost-cutting measures directly and inevitably led to Sarah's injury. But the fight is far from over. Now it's Megacorp's turn for cross-examination. The defense lawyer approaches Dr. Reed again, but this time the friendly facade is gone. His questions are rapid-fire, designed to chip away at her credibility. Doctor, you conducted your analysis based on photographs and reports, correct? You never personally visited the site within 24 hours of the incident, did you? No, I was retained 3 months after the fact. So you didn't see the initial state of the debris? You're relying on someone else's photos. He's implying her analysis is secondhand, incomplete. He then brings up her fee again. $50,000. That's what you've billed so far for your work on this case, correct? Would you say that gives you a vested financial interest in your client winning? He's trying to poison the well, to make the jury see her not as an objective scientist, but as a paid participant in the lawsuit. He questions her methodology, citing obscure academic articles he claims contradict her findings, forcing her to defend her professional conclusions in a flurry of technical jargon. He's trying to muddy the waters, to turn her clear, damning testimony into a confusing battle of the experts, where the jury just throws up their hands and doubts everyone. Dr. Reed parries every thrust, her composure unshaken. She defends her methodology, clarifies the context of the articles, and stands by her conclusions. She seems invincible. But then the Megacorp lawyer walks back to his table and picks up a thin blue folder. He approaches the witness stand with a slight smirk. Dr. Reed, you testified that the use of zinc-plated bolts was the sole cause of the collapse. Are you familiar with a company called Apex Maintenance Solutions? Dr. Reed hesitates for just a second. The name is not familiar to me. The lawyer's smirk widens. He opens the folder. Well, that's interesting. Because we have maintenance records, signed 3 weeks before the incident, showing that Apex Maintenance was hired by the building owner to perform repairs on the exact section of ceiling that collapsed. Let me show you what we've marked as Defense Exhibit C. He places a document in front of her, and the entire courtroom leans in, trying to see what could possibly unravel their star witness. It's a work order, dated 2 weeks before the accident. Sarah stares at it, her face going pale. It's a standard maintenance request form from the building's management company. The request details a need for minor plaster and paint touch-ups in the living room. At the bottom, in the section marked Tenant Approval, is a signature. Her signature. Mr. Davies lets the silence hang in the air for a moment, a predator letting its prey realize it's trapped. Ms. Miller, he says, his voice now soft, almost sympathetic. Could you please identify the document marked as Defense Exhibit C? And here we see a key piece of courtroom procedure, the introduction of an exhibit. An exhibit is simply a formal name for any document, object, or piece of evidence presented in court. Could be a photograph, a contract, a weapon, or in this case, a work order. Each piece is given a number or letter so it can be easily referenced throughout the trial, just like Defense Exhibit C. Sarah's eyes dart from the paper to her lawyer, Ms. Chan, who looks like she just swallowed a hornet. It looks like a work order, Sarah stammers. It is a work order, Davies corrects gently. Is that your signature at the bottom, Ms. Miller? I think so. You think so? Or you know so? He presses, his voice hardening just a fraction. Yes, it's my signature. And this work order which you signed authorizes maintenance to perform, and I quote, minor plaster and paint touch-ups on the ceiling, correct? Yes, but...
No but, Ms. Miller.
Just a yes or no. Is that what it says? Yes. He picks up the document and walks toward the jury box, holding it so they can see. Ladies and gentlemen of the jury, this is a work order, signed by the plaintiff's own star witness, authorizing the very repair work she just testified, under oath, that she never requested and was never aware of. He turns back to Sarah. The trap is sprung. What Mr. Davies is doing is called impeachment. Now, in a political context, impeachment means charging a public official with a crime. But in a courtroom, to impeach a witness means something very different. It's the process of discrediting them. It's an attempt to show the judge and jury that the witness's testimony should not be believed, either because they are lying, they're mistaken, their memory is faulty, or they have a bias. By presenting a document that directly contradicts her sworn testimony, Davies is trying to impeach Sarah's credibility. He's planting a seed of doubt. If she was wrong about this, what else might she be wrong about? And this is where things get really serious. If a witness is just mistaken, that's one thing. But if they knowingly lie under oath, that is a crime called perjury. Perjury is a felony, and it can carry severe penalties, including prison time. The entire legal system is built on the foundation of people telling the truth under oath. Perjury is an attack on that very foundation. Davies isn't explicitly accusing her of perjury yet, but the implication is hanging thick in the air. He continues his cross-examination. So, Ms. Miller, a moment ago you testified, and I have the transcript right here, that you made, quote, at least a dozen calls to the landlord about a large, growing crack in the ceiling. Is that correct? Yes, that's right. And yet, this work order which you signed describes the issue as needing minor plaster and paint touch-ups. Those two descriptions seem quite different, wouldn't you agree? Sarah is flustered. Well, I might have downplayed it on the form. I just wanted someone to come look at it. You downplayed a large, growing, dangerous crack as a minor touch-up? Davies asks, his eyebrows raised in theatrical disbelief. Why would you do that? I don't know. Leo's lawyer, Ms. Chun, has seen enough. She stands up abruptly. Objection. This is one of the most famous words in any legal drama. An objection is a formal protest made by a lawyer to a judge. They're essentially saying, hold on, the other side is breaking the rules. There are many reasons to object. The question might be irrelevant to the case. It might be asking for hearsay, which is basically second-hand information, something the witness didn't see or hear themselves. Or, as is the case here, the question might be argumentative. On what grounds, Ms. Chun? The judge asks, her voice even. Counsel is being argumentative, Chun says. He's not asking for facts. He's arguing with the witness and characterizing her testimony. An argumentative question is one that challenges the witness to agree with the lawyer's own conclusions, rather than just stating facts. It's the lawyer's job to argue the case, not the witness's. The judge considers this for a second. This is the crucial moment. The judge has two choices. She can sustain the objection, or she can overrule it. If she sustains the objection, it means she agrees with Ms. Chun. Mr. Davies would have to rephrase his question or move on. The witness would be instructed not to answer. If she overrules the objection, it means she disagrees. The question stands and the witness must answer it. The objection is overruled, the judge says. The witness will answer the question. Counsel is on a tight leash, but he's entitled to test the witness's credibility. A small victory for the defense. A major blow to the plaintiff. Davies turns back to Sarah, his eyes boring into her. I'll ask you again, Ms. Miller. Why would you describe a large, dangerous crack as a minor touch-up? Sarah shrinks in the witness box. The confidence she had just minutes ago is gone, replaced by a panicked uncertainty. I just wanted it fixed. I thought if I made it sound simple, they would get to it faster. It's a plausible answer, but the damage is done. Her credibility is now riddled with holes. The jury is looking at her differently. They're no longer seeing a concerned friend who tried to prevent a tragedy. They're seeing someone whose story has changed under pressure. Someone who signed a document that tells a completely different story from the one she told under oath. Davies senses he's made his point. He doesn't need to push any harder and risk the jury feeling sympathy for her. He takes a step back. No further questions for this witness, Your Honor. His job for now is done. He has successfully impeached the plaintiff's key witness. He has used an exhibit to create a powerful contradiction. He has navigated an objection and come out on top. He has planted the seeds of reasonable doubt. But it's not over. Not by a long shot. Miss Chun is now on her feet. She looks at her witness, Sarah, who appears shaken and defeated. She then looks at the jury, who are whispering amongst themselves. She knows she has to do something to repair the damage. The rules of the court give her one more chance to question her own witness. This next phase is called redirect examination, or sometimes just redirect. The purpose of redirect is very specific. It's not a chance to redo the entire testimony. The lawyer is only allowed to ask questions about topics that were brought up during the cross-examination. It's a damage control opportunity. Ms. Chen's goal will be to rehabilitate her witness, to give Sarah a chance to explain the inconsistencies, to clarify her answers, and to restore some of her lost credibility in the eyes of the jury. It's her chance to take the narrative that Mr. Davies has shattered and try to piece it back together. The whole case might depend on it. She takes a deep breath and gives Sarah a reassuring nod. Ms. Miller, she begins, her voice calm and steady. I just have a few more questions for you. Did Mr. Davies seem aggressive to you when he was asking you questions? Before Sarah can answer, Mr. Davies is on his feet. Objection, Your Honor. Leading the witness. The judge looks at Ms. Chun. Sustained. Rephrase, counsel. And right there, in that quick exchange, we see two fundamental pillars of trial procedure: the objection and the concept of a leading question. An objection is simply a formal protest raised in court during a trial to disallow a witness's testimony or other evidence which would be in violation of the rules of evidence. Think of it as a referee blowing the whistle in a sports game. A foul has been committed, and the game has to stop for a moment to sort it out. The lawyer isn't just being difficult, they are legally required to object at that very moment, or they risk waiving the right to protest that error later on appeal. You can't wait to see if you like the answer and then object. It's now or never. The judge then acts as the ultimate referee. They can either sustain the objection, which means they agree with the objection and the question must be withdrawn or rephrased, or they can overrule the objection, meaning they disagree and the witness must answer the question. In this case, Mr. Davies objected because Ms. Chun asked a leading question. So what does that mean? A leading question is one that suggests the answer, or contains the information the lawyer is looking for. Notice how Ms. Chun didn't ask, "What was Mr. Davies's demeanor?" She asked, "Did Mr. Davies seem aggressive?" The word aggressive is the answer she wants Sarah to confirm. She's leading the witness to her desired conclusion. Now, here's the fascinating part. Leading questions are not always forbidden. It depends entirely on who is asking the questions. During direct examination, which is what Ms. Chun is doing now, questioning her own witness, leading questions are generally not allowed. The idea is that the witness should tell their own story in their own words, not just parrot back what their lawyer feeds them. But during cross-examination, which is what Mr. Davies was doing earlier, leading questions are not only allowed, they are the primary tool. The goal of cross-examination is to test the truthfulness and accuracy of the witness's testimony, to control the witness, and to poke holes in their story. The most effective way to do that is with very specific yes or no questions that don't give the witness wiggle room. "You were looking at your phone, weren't you?" is a classic leading question you'd hear on cross-examination. Ms. Chun, a seasoned pro, knows this. She nods unfazed. "My apologies, Your Honor." She turns back to Sarah. "Ms. Miller, could you please describe for the jury Mr. Davies's tone and manner during his questioning of you?" Sarah takes a breath. "He was loud. He kept cutting me off. It felt like he was trying to twist my words." Objection. Davies is up again. "Calls for speculation as to my state of mind." Overruled, the judge says flatly. The witness is describing her perception of the questioning. She may answer. Davies sits down, a flash of irritation on his face. Ms. Chun has scored a small but important point, re-establishing Sarah's credibility and humanity after Davies's aggressive cross-examination. "Thank you, Ms. Miller," Ms. Chun says gently. "Now, I want to go back to the moment just before the impact. You mentioned you were on a hands-free call with your friend Jessica Riley. What did Jessica say when she heard the crash through the phone?" Objection, Your Honor. Hearsay. This is the big one. The one you've heard 100 times in movies. Hearsay. It's one of the most famous and most misunderstood concepts in law. Most people think hearsay just means something someone else said. But it's more specific and much more complex than that. The formal definition of hearsay is an out-of-court statement offered in evidence to prove the truth of the matter asserted. Let's break that down. It has 3 parts. 1. It has to be an out-of-court statement. Something said or written outside of this specific court proceeding. What Jessica said on the phone is a perfect example. 2. It's offered in evidence. The lawyer is trying to get the jury to hear it and consider it as a fact. 3. This is the crucial part. It's being offered to prove the truth of the matter asserted. This means Ms. Chun wants the jury to believe that whatever Jessica said is true. Why is this a problem? Because the person who originally made the statement, in this case Jessica, is not in court under oath and cannot be cross-examined. Mr. Davies can't ask Jessica, "Were you really paying attention? How do you know what you heard? Isn't it possible you misheard?" The court system is built on the idea of confronting one's accusers and testing the evidence. Hearsay short-circuits that entire process. It's like playing the telephone game. By the time the message gets to the jury, it could be completely distorted, and there's no way to check the original source. The judge looks at Ms. Chun. "Counsel, that is textbook hearsay. I'm not offering it for the truth of the matter, Your Honor." Ms. Chun counters smoothly. "I am offering it to show the witness's state of mind immediately following the crash. It's a present-sense impression." And just like that, we've stumbled into one of the nearly 30 exceptions to the hearsay rule. Yes, 30. Hearsay is like a giant wall, but it's a wall full of doors and windows. An experienced lawyer knows where all of them are. An exception like present-sense impression allows a statement if it describes an event made while the person was perceiving the event, or immediately thereafter. The law trusts these statements more because there's no time to think up a lie. Another famous exception is the excited utterance, a statement made about a startling event while the speaker is still under the stress of the excitement. If Jessica had screamed, "Oh my God, a speeding truck!" that might have qualified. The judge considers this for a moment. I'll allow it, but for that limited purpose only. The jury will be instructed not to consider the statement as proof of what actually happened, but only as it relates to Ms. Miller's state of mind. Ms. Chun nods. "Thank you, Your Honor." She turns to Sarah. "Ms. Miller, what did you hear Ms. Riley say over the phone?" Sarah's voice is quiet. "She just screamed my name, over and over." Sarah, are you okay?" "I think that's what snapped me out of it." The testimony hangs in the air. Ms. Chun didn't need the jury to believe Jessica's words were a factual account of the crash. She needed them to feel the terror and chaos of that moment through Sarah's ears. And she succeeded. "One last topic, Ms. Miller," Ms. Chun says, her voice steady. "You testified earlier that the defendant's truck was moving very fast. Can you tell the jury how you knew that?" Objection. Lack of foundation. Davies is on his feet again, but this time his tone is more confident. This objection, lack of foundation, is another crucial one. It means the lawyer hasn't laid the proper groundwork to show that the witness is competent to testify about a particular fact. You can't just have a witness say, "The car was going 80 miles per hour." You first have to establish how they know that. Did they see the speedometer? Do they have special training like being a police officer? Did they have a clear, unobstructed view for a long enough time to make a reasonable estimate? Without that groundwork or foundation, the testimony is just a guess. It's like a builder trying to put a roof on a house that has no walls. The judge agrees. Sustained. "Lay your foundation, Ms. Chun." Ms. Chun doesn't miss a beat. "Ms. Miller, how long have you been driving?" 15 years. "And what is your daily commute like?" "I drive about 40 miles each way on the highway." "I-95. So in a given week, how many hours would you say you spend on the highway, observing the speed of other cars?" "Oh, at least 10 or 12 hours a week." "And for your job, what do you do?" "I'm a logistics coordinator for a shipping company. I manage a fleet of delivery trucks." "And does that job require you to have an understanding of vehicle speeds, travel times, and safety protocols?" "Yes, every single day." Ms. Chun has just built her foundation brick by brick. She has established that Sarah is not just some random person making a wild guess. She is an experienced driver and a logistics professional whose job revolves around vehicle movement. "Now, Ms. Miller," Ms. Chun says, her voice resonating with newfound authority, "based on your 15 years of driving experience and your professional expertise, how fast would you estimate the defendant's truck was traveling when it ran the red light?" Davies stays seated. He knows he's lost this battle. Sarah looks directly at the jury, her voice clear and certain. He was going at least 50 miles per hour. The speed limit on that street is 30. He wasn't just speeding. He was flying. The air in the courtroom crackles. Every eye is on Sarah, then pivots to Mr. Davies's lawyer, who rises slowly, a tight, forced smile on his face. This is the moment he's been waiting for. This is what's known as a cross-examination. If direct examination is about building a story, cross-examination is about tearing it down. It's the opposing counsel's chance to question the witness, to challenge their testimony, to find inconsistencies, and to plant seeds of doubt in the minds of the jury. It's inherently adversarial. The lawyer isn't there to be your friend. They are there to dismantle everything you just said. And they have a special tool to do it, the leading question. A leading question is one that suggests the answer. On direct examination, Sarah's lawyer couldn't ask, "You saw the blue car run the red light, didn't you?" That's leading the witness. He had to ask open-ended questions like, "What did you see?" But on cross-examination, the gloves come off. Leading questions are not only allowed, they are the primary weapon. Davies's lawyer approaches Sarah. "Ms. Miller, you were on your way to a very important meeting, correct?" "Yes, a job interview." "A job interview you were running late for, isn't that right?" I was a little behind, yes." "So you were in a hurry. You were stressed. Perhaps a bit distracted. You see what he's doing?" He's not asking if she was distracted. He's stating it as a fact, embedded in a question, forcing her into a defensive position. He's painting a picture for the jury. A frantic, stressed woman, not a calm, reliable observer. "And it was a bright day," he continues. "The sun was low in the sky, wasn't it?" "It was morning, yes." "Creating a glare on the road? Isn't it true that the sun was in your eyes, making it difficult to see clearly?" "There was some sun, but it wasn't in my eyes." "So your testimony is that you have a perfect photographic memory of an event that happened in a split second, on a day you admit you were late and stressed, with the sun creating a glare?" Sarah's lawyer stands up. "Objection." And there it is. That famous word. An objection is a formal protest made to the judge. It's a lawyer's way of saying, "Hold on, Your Honor, that's against the rules." There are dozens of reasons to object. The question is irrelevant, it assumes facts not in evidence, or in this case, it's argumentative. The lawyer isn't asking a question. He's making a speech. The judge looks at Davies's lawyer. "Sustained." "Rephrase the question, counsel." "Sustained." That means the judge agrees with the objection. The lawyer has to back off and try another way. If the judge had said overruled, it would mean he disagreed, and Sarah would have had to answer the question. It's a verbal tennis match, and the judge is the umpire deciding which shots are in and which are out. Davies's lawyer regroups. "Ms. Miller, did you speak to anyone at the scene after the accident?" "Yes, I spoke to a man who was walking his dog." "And what did this man say to you?" "He said he saw the whole thing and that the driver..." Objection. Sarah's lawyer is on his feet again. Hearsay. This is perhaps the most famous and most misunderstood objection of all. Hearsay, in simple terms, is secondhand testimony. It's a witness trying to testify about something they didn't see or hear themselves, but rather something someone else told them. The law says that's generally not allowed. Why? Because it's not reliable. The person who actually saw it needs to be the one on the stand, under oath, subject to cross-examination. You can't cross-examine a memory of a conversation. It's like the telephone game. By the time the story gets to the courtroom, it could be completely distorted. The man with the dog isn't here to be questioned, so Sarah can't testify as to what he said. The judge nods. Sustained. Davies's lawyer is getting frustrated. His attempts to discredit Sarah are being blocked. He tries a few more questions about her distance, her angle, her state of mind, but her answers remain clear and consistent. Finally, he sighs, defeated. "No further questions, Your Honor." Sarah steps down from the witness stand, her part in this drama over. She has presented her evidence. Now, the fate of her case shifts from the witness stand to the jury box. And this brings us to one of the most fundamental concepts in the entire legal system: the burden of proof. The burden of proof is the obligation on one party to prove its case. In a courtroom, you don't just walk in and make accusations. You have to back them up with evidence. The question is, how much proof do you need? And the answer depends entirely on the type of case. This is a civil case. Sarah is suing Mr. Davies for damages. In a civil case, the burden of proof is called a preponderance of the evidence. It sounds complicated, but the concept is beautifully simple. Imagine the scales of justice. To win, Sarah's lawyer doesn't need to bury the other side of the scale. He just needs to tip it, ever so slightly. He needs to convince the jury that his version of events is just a little more likely to be true than not true. We're talking 50.1%. If the jury thinks, it's a close call, but we think it's more probable that Mr. Davies was negligent, then Sarah wins. It's a standard based on probability, not certainty. This is a huge contrast to the burden of proof in a criminal trial, which is what most of us see on television. In a criminal case where someone's liberty is at stake, the government must prove the defendant's guilt beyond a reasonable doubt. This is the highest standard of proof in the law. It's not 50.1%. It's not 70%. It's not even 99%. There's no number because it's about a state of mind. It means the jury must be so convinced that there is no other logical explanation, based on the facts presented, for what happened. It doesn't mean beyond all doubt. You could have a doubt that the sun will rise tomorrow, but it's not a reasonable one. But if there is a real, sensible, logical doubt based on the evidence or lack thereof, the jury must find the defendant not guilty. Think of it this way. The preponderance of the evidence is a feather's weight tipping the scales. Beyond a reasonable doubt is a mountain sitting on one side of the scale, with nothing on the other. So, as the jury in Sarah's case listens to the last of the evidence, they aren't asking themselves, "Are we 100% certain Mr. Davies was speeding?" They're asking a much simpler question. Based on everything we've heard and seen, the skid marks, the damage to the cars, and the testimony of that very credible eyewitness, Sarah Miller, is it more likely than not that he was negligent? The lawyers will soon give their closing arguments, their final chance to frame the story for the jury. Sarah's lawyer will talk about responsibility and the clear evidence. Davies's lawyer will talk about reasonable doubt, even though that's the wrong standard, and the impossibility of being certain. He'll try to muddy the waters. The entire case now rests on those 12 ordinary people in the jury box. They hold the scales, and everyone in the courtroom is waiting to see which way they will tip. The 12 jurors file out of the courtroom, their faces a collection of unreadable masks. They are led to a private room, a space that will become their entire world for the next several hours, or perhaps even days. This is the deliberation. It's a sacred, secret process where they will dissect every piece of evidence, every testimony, every argument they've heard. The door closes and they are officially sequestered, cut off from the outside world. No phones, no news, no family. Just them, the evidence, and the immense weight of the law. Inside that room, their first task is to elect a foreperson, a leader who will guide the discussion and act as their spokesperson. Then the real work begins. They must revisit the facts, debate the interpretations, and apply the judge's instructions on the law. It's a process of persuasion, of listening, of wrestling with doubt. Was the witness credible? Did the alibi hold up? Does the physical evidence point to only one conclusion? They must be unanimous. Every single one of them must agree on the verdict. If even one juror holds out, there is no decision. Back in the courtroom, time stretches into an agonizing crawl. The defendant sits stone-faced, the lawyers make quiet conversation. Families on both sides hold their breath. Then a message comes from the jury room. They have a verdict. The jurors file back in, their expressions just as guarded as before. The foreperson hands a folded piece of paper to the bailiff, who gives it to the judge. The judge reads it, his face betraying no emotion, and hands it to the clerk to be read aloud. The clerk's voice cuts through the silence. On the charge of, we the jury find the defendant. And here lies one of the most misunderstood moments in law. The verdict will either be guilty or not guilty. Notice, the word isn't innocent. The legal system doesn't declare someone innocent. A not guilty verdict, known as an acquittal, simply means the prosecution failed to prove its case beyond a reasonable doubt. It means the state did not meet its burden of proof. It's a subtle but crucial distinction. The system isn't designed to prove innocence. It's designed to prevent the conviction of anyone who hasn't been proven guilty to that very high standard. But what if the jurors can't agree? What if, after hours or days of deliberation, they are hopelessly deadlocked? This is called a hung jury. If the judge is convinced they will never reach a unanimous decision, he will declare a mistrial. A mistrial essentially voids the trial as if it never happened. It's not an acquittal or a conviction. The prosecution is then free to try the case all over again with a new jury, and often they do. The entire grueling process starts from scratch. Let's imagine, however, that in our case, the verdict is guilty. The immediate relief or despair that floods the courtroom is only temporary, because the case isn't over. The next phase is sentencing. The judge will set a date for a sentencing hearing. During this hearing, both sides will present arguments about what the appropriate punishment should be. The prosecution will present aggravating factors, reasons why the sentence should be harsher. Perhaps the crime was particularly cruel, or the defendant has a long criminal history. The defense, in turn, will present mitigating factors, reasons for a more lenient sentence. Maybe the defendant showed genuine remorse, had a difficult upbringing, or played a minor role in the crime. The judge will consider all of this, along with pre-sentencing reports and sentencing guidelines, before making a final decision. The sentence could be probation, where the defendant is released but must adhere to strict conditions. Could be fines, community service, or, most seriously, incarceration, prison time. The judge might also decide whether multiple sentences will run concurrently, meaning they are served at the same time, or consecutively, meaning they are served back-to-back, one after the other. But even after the sentence is handed down, the legal battle can continue. If the defense believes a serious legal mistake was made during the trial, they can file an appeal. This is where a whole new set of legal language comes into play. The person filing the appeal is the appellant, and the other side is the appellee. The appellant isn't arguing their innocence in the same way. An appeal is not a new trial. No new evidence is presented, and no witnesses are called. Instead, the appellant submits a written argument called a brief to a higher court, known as an appellate court or court of appeals. This brief must argue that a significant error of law occurred during the original trial. Maybe the judge improperly allowed certain evidence to be shown to the jury. Maybe the jury was given incorrect legal instructions. Or perhaps the argument is based on ineffective assistance of counsel, claiming their own lawyer was so incompetent that they didn't get a fair trial. The appellate court, typically a panel of 3 or more judges, reviews the trial record, the transcripts of everything that was said and all the evidence that was presented. They read the briefs from both the appellant and the appellee and may hear oral arguments from the lawyers. They are not retrying the facts of the case. They are looking for legal errors so significant that they might have changed the outcome of the trial. If the appellate court agrees with the appellant, it can do a few things. It might reverse the conviction entirely, setting the defendant free. More commonly, it will remand the case, send it back to the lower court for a new trial, a do-over without the legal error. If the appellate court finds no significant error, it will affirm the lower court's decision, and the conviction stands. And for some, the journey doesn't even end there. If the appellant loses their appeal in the state appellate court, they can sometimes appeal to the state's highest court, often called the state Supreme Court. And in cases that involve questions of federal law or the U.S. Constitution, a party can petition the highest court in the land, the Supreme Court of the United States. They do this by filing a writ of certiorari, a formal request for the Supreme Court to hear their case. The Supreme Court receives thousands of these petitions every year and agrees to hear only a tiny fraction, usually around 100 cases. For a case to be heard, at least 4 of the 9 justices must agree to grant cert. Once a case has been through the trial and the entire appeals process is exhausted, the decision is generally final. This brings us to a foundational legal principle, residential judicata, a Latin phrase meaning, a matter judged. It's a doctrine that prevents the same case from being litigated over and over again. It provides finality, ensuring that at some point the legal process comes to an end. And the decisions made in these cases, particularly by the appellate and Supreme Courts, do something more. They create precedent. This is the core of our common law system, guided by the principle of stare decisis, which means to stand by things decided. When a higher court makes a ruling on a point of law, that ruling becomes a binding precedent for all lower courts in its jurisdiction. Future judges facing similar cases must follow that precedent. This ensures that the law is applied consistently and predictably. A single case born from a single event can ripple through time, shaping the interpretation of our laws and the very fabric of our rights for generations to come. From a simple complaint to a final appeal, from a subpoena to stare decisis, the language of the law is the architecture of our society. It can feel like a fortress, impenetrable and intimidating. But it's not. It's a system built on words, and those words have meaning. By understanding them, you're not just learning definitions. You're gaining a map to navigate a complex world. You're empowering yourself to understand your rights, to advocate for yourself, and to participate more fully in a system that, for better or worse, governs us all. The law is not just for lawyers, it is for everyone. And now you speak its language.